Hello and welcome to Topic 6, Lecture 1, and in this lecture we're going to be learning about criminal defenses. So last week we learned about the elements of the crime, actus reus, mens rea, etc. And so you were looking at the criminal justice system through the lens of the prosecutor. And the goal of the prosecutor is that to get a prosecution, the prosecution must prove beyond a reasonable doubt that the accused engaged in or possessed each element of the crime. This week, we're going to be looking at the criminal justice system and at criminal law through the lens of the defense attorney. Now, before we move forward, I just want to make sure that our minds are all refreshed and that we remember what the actual elements of the crime are. Because the elements of the crime are important for the prosecutor, but the elements of the crime are really important for the defense attorney as well, because the goal of the defense attorney is to raise doubt or to refute one of the elements of the crime, if not more. So just as a refresher, remember that one of the first element of a crime is what's known as actus reus. And so that you have to prove or refute that the person accused of the crime engaged in a criminal act, actus reus, the guilty act. Then you either need to prove or refute that the accused had the intent to commit the criminal act, that they possessed mens rea, that they possessed the guilty mind, okay? In other words, that they knowingly and intentionally committed the crime. We also talked last week about how that you have to prove or refute that the defendant's actions were the close to or the immediate cause of the injury, right? Because when a criminal act is associated with harm, and so you have to prove that that the harm was caused by the criminally accused or raised doubt about that, okay? And so that you had to prove that the action is the immediate or in close relationship with the harm. And then you actually have to demonstrate that there was actual harm that was caused and that how a person is charged is related to the harm that they actually caused, okay? So keep those in mind. I just wanted to go over that again so that we are all on board as we are looking at the way that the criminal defense attorney will raise doubt or refute the elements of the crime. The goal of a criminal defense is to refute one or more of the elements of the crime, okay? So the goal of a criminal defense is basically to raise doubt as it revolves to one of those elements of the crime. And while the prosecutor has to prove all of the elements of the crime, the defense attorney's job is a little bit easier, not really, but if you raise doubt about only one of the elements of a crime, well, then that's enough to get an acquittal because the prosecutor needs to prove all of the elements of the crime. So for example, one thing a defense attorney can do is that they can raise doubt or refute and deny actus reus. They can basically say that, yes, a criminal act took place, but my client didn't commit that criminal act, okay? My client is falsely accused. You've got the wrong person, okay? And so methods of raising doubt about actus reus you'll say, look, there's no physical evidence linking my client to the scene of the crime. There's no eyewitness or surveillance technology that puts my client at the crime scene, okay? There's no confession, right? And so those are all general ways of raising doubt or refuting actus reus. Now, criminal defense attorneys do this to varying degrees of success. This week, we're going to be watching the documentary The 13th, and they're going to reference a famous case of 5 juveniles who were falsely accused of raping a woman in Central Park in 1989, and they're referred to as the Central Park Five. The Central Park Five, it's a famous case regarding 5 juveniles who were wrongly convicted of raping the jogger, and that despite that there was no physical evidence linking these individuals to the crime, they were convicted anyways. The police officers coerced confessions out of them, etc. And so the five were convicted, and they served between 5 and 13 years, varying depending on which individual it was. And then in 2002, through DNA evidence, that it was discovered that none of the five were involved in this incident, that they were, in fact, wrongly accused. And then they were exonerated and released. Okay, so that's a good example of after the fact, right? For people getting exoneration, but their attorneys did raise doubt, but unsuccessfully, in terms of calling into question whether or not their client had engaged in the guilty act. Another thing that a defense attorney can do is that they can call into question mens rea. Okay, they can say, look, my client did engage in this act, but my client did not possess mens rea. They did not have the capacity to possess criminal intent, and therefore they cannot be found guilty. Okay, those are known as excuse defenses, and we're going to look at those in more detail in a moment. That a defense attorney can also say, my client did engage in the act, and in fact, they intended to engage in this act, but that they were justified in engaging in this act. And those are called justification defenses, and we'll look at those in more detail in a moment. A defense attorney can also refute the harm, right? You can say, well, my client engaged in this action, but their action didn't result in the harm. A really good example of that is the case from 1997, older cases here, but good examples of Louise Woodward. She was an au pair, like a nanny. That's what an au pair is, from England. And that while she was watching a child in her nanny capacity, that the child died. And that she was convicted of involuntary manslaughter. What she was convicted of was shaken baby syndrome. So that she was convicted of shaking a baby so hard that they had a brain trauma and died. What her defense attorney did, unsuccessfully, but it's still a good example of refuting harm, is they said that, yeah, Louise was trying to rock the baby and settle the baby down, but they didn't shake the baby. And in fact, if you look at the forensics of the autopsy, that the defense attorney said this baby already had harm done to their brain, that their parents had abused this baby, and that just the gentle rocking that the nanny had done, like, reopened the brain bleed that was in the baby. Okay, it was unsuccessful, but it's a good example of saying, yeah, my client did move the baby, but not to the point of causing that harm. Let's turn our sights now to excuse defenses. And in an excuse defense, the argument that the defense attorney makes is that the accused should be excused from the criminal action because they lack the capacity to form sufficient intent to be held responsible. And so in excuse defenses, the focus is on mens rea. That the defense makes an argument that their client did engage in actus reus, but they did not know that they were committing a crime. They didn't understand the consequences of their actions. They didn't intend to commit a crime. So they raised doubt about mens rea, basically saying that the client didn't have the capacity to understand the consequences of their actions. So let's take a look at some common excuse defenses. So your textbook looks at 5 excuse defenses, and we're going to take a look at 3 of these in lecture. And so insanity is an excuse defense. The person's age can be an excuse defense. Intoxication can be an excuse defense. Entrapment and duress. Okay, so we'll cover the ones that are in red, but it's up to you to cover entrapment and duress from the information in the textbook. So the first excuse defense we're going to look at is the insanity defense. Insanity is a defense in which the defendant's state of mind negates their criminal responsibility. In other words, that the argument is that because of mental illness, that this person was not able to understand the consequences of their actions, that they really did not possess criminal intent, mens rea. They didn't possess mens rea. And that's why they should be excused from their actions. They should be excused because their mental illness prevented them from possessing mens rea. And so keep in mind that having a mental illness in and of itself is not a defense. For one, there's a lot of people in the United States and throughout the world who have mental illness and do not commit criminal offenses. Even if you do have a mental illness and you commit a criminal offense, that doesn't mean that you are automatically, assumed to not possess mens rea. That the defense attorney has to demonstrate that the mental illness itself made it incapable for the accused to understand the consequences of their actions. Okay, that the mental illness made them incapable of possessing mens rea. So, for example, if you have schizophrenia and that you're on antipsychotic medications, right, and you commit a crime, well, you're probably very capable of possessing mens rea because the medicine you were on kept your psychotic states at bay, kept them in check. You were not experiencing those during the time that you were involved in your criminal action. However, if you have schizophrenia and you're off your medications and you're in a full-blown psychotic episode and you commit a criminal offense, then you'd have a more successful chance as a criminal defense attorney to say that your client was not capable of understanding the consequence of their action because they were in a psychotic state. A successful defense, insanity defense, results in a verdict of not guilty by reason of insanity. But keep in mind that even though you're found not guilty, that you are not set free. And that usually the court, if not always, the court will commit that individual to a mental institution in order to get the treatment that they need to make sure that they are not going to harm others. And then when they can demonstrate that they no longer pose a threat to society, then they could possibly be released. Good example of that is a case that I'm sure you're all familiar with, the Slenderman case from Waukesha in 2014. That was the case of two 12-year-olds, Anissa Weir and Morgan Geyser, who lured their friend into a local park and attempted to stab her to death in order to, have an offering to the Slender Man, a character in these horror stories. They were initially charged as adults for attempted first-degree homicide, but then as the case went on, they were finally found to be not guilty due to reason of insanity. Both were committed to mental health institutions. Just recently, Anissa Weir was released, but Morgan Geyser is still in confined capacity in an institution. The next excuse defense is age, okay? And so, here we're asking the question, can a child willingly, knowingly engage in a crime, right? In other words, are children capable of possessing criminal intent? Are they capable of possessing mens rea? The answer to the question is, it really depends on the age of the child. So when it comes to age as an excuse defense, it really revolves around the age of the child. And so that the older a child is, and a child is defined as anybody under the age of 18, okay? So from 0 to 17, hopefully we don't have any murdering infants, right? But, that as the child gets older, they come closer to being capable of possessing criminal intent, possessing mens rea, okay? And so that under the age of 7, so from 0 to 6 years old, that there's a presumption, a very strong presumption of incapacity. There's a presumption that they are incapable of possessing mens rea, possessing criminal intent, okay? So as it says there, that a child under the age of 7 is presumed to not have the capacity to understand the consequences of their actions, and therefore criminal responsibility would be negated, okay? Between the ages of 7 and 14, that it's possible that they have the capacity to possess mens rea. So as it says there, between the ages of 7 and 14, a child may have the capacity to understand the consequences of their actions, that they may have be held criminally responsible. Okay. And then over the age of 14, so from 15, 16 to 17, that the court assumes that the child does have the capacity to understand the consequences of their action, that they have the capacity to understand the consequences of their actions and the ability to possess mens rea, and that they should be held responsible. Okay? So the older you are, the more likely it is that you are deemed capable of understanding the consequences of your criminal actions. Now, in each of these instances, it's both the prosecution and the defense can challenge the presumption. Okay, so for example, let's say that your client, as a defense attorney, is 15 years old. Well, the court's going to assume that they have the capacity to understand and should be held criminally responsible for their actions. But a defense attorney, a good defense attorney, could say, hey, look, that this is not a normal 15-year-old, right? That maybe that they don't, that they intellectually don't have the capacity, that they are not at the same level in terms of intellectual capacity as other 15-year-olds, etc. So a defense attorney could make a case to say that, yeah, their age says 15, but they're really closer to being an 8-year-old, okay? On the flip side of that, a good prosecutor could say, well, we got ourselves here a 6-year-old, but this is a really advanced 6-year-old, right? And that they're able of understanding the consequences of their criminal actions. Not likely that a prosecutor is going to do that because it's not super popular. But recently, we had the instance of a young person bringing a gun to school, right? And so, that's, clearly that you could try to make the case one way or the other. And then it would ultimately be the judge who would determine whether or not this child is going to be, tried as an adult. But also that argument about the excuse defense, right? That you're making a case to the jury that this individual does not have this capacity, right? And shouldn't be held responsible. Now, old age doesn't fall in the presumption of incapacity, right? So it's not like the younger you are, the more you're not capable of understanding your consequences of your criminal actions. And that when you get to be super old, 80 and 90-year-olds aren't capable of understanding the consequences, that they lack that capacity and they could use that as a defense. Doesn't work that way. Old age would not fall into this category of the presumption of incapacitation. What we would look at is that the mental disease or defect, right? That you could say, well, an older person has dementia, and dementia prevents them from understanding the consequences of their actions, okay? But it falls outside of the age as an excuse defense. So this leads us to our third excuse defense, which is intoxication. In other words, that you should be excused from committing this crime because you were drunk and you didn't know what you were doing. Now, in general, as a rule, intoxication is not considered an allowable defense. It's only allowable if you can demonstrate, if the defense attorney could demonstrate that the intoxication is somehow involuntary. In other words, that you were drugged or made drunk without your knowledge, okay? And so that's usually the only time that intoxication is an allowable defense, right? So if the defense attorney can say, look, this guy went into a bar, he ordered a cranberry juice, he's, that was not drinking, but then somebody slipped some drug in it and then he drove and killed somebody, you could potentially use that as an effective excuse defense. That being the case, intoxication can reduce charges, but it can't excuse it from the crime. So if you kill somebody while you are completely out of your gourd drunk, it's likely that could be reduced to second degree or even some sort of manslaughter. So while the charge might be reduced, you're not going to be excused from from your criminal action. It may just be a reduced level of criminal action. So why is it that intoxication isn't an allowable defense? I mean, you're drunk, you don't know what you're doing. How could you possibly possess mens rea? Well, yeah, it's true that while at the time of being intoxicated, you may not knowingly or willingly engage in a crime. In fact, you might not even remember engaging in the crime. However, that prior to the crime, you knew that if you got drunk or took a bunch of drugs, that you knew that it could lead to something harmful. And so you should have known better, right? So that's why the intoxication defense is rarely allowable in a court of law. All right, so those are the excuse defenses. Let's turn our sights now to the justification defenses. In the justification defense, the defendant acknowledges that they committed an act, okay? But they claim that they can't be prosecuted because they were justified in engaging in the criminal action. So in this, and with justification defenses, you're not questioning actus reus. The criminally accused and their attorney would say, they did it. This person admits to engaging in this criminal action. But they say that they don't question actus reus. I did it, but I had permission to do it. Therefore, it's not a crime. Okay, that's one approach. Another approach is that they say that they don't question actus reus. I did it. And in fact, I intended to do it. Okay. However, anybody in this circumstance would have done the same, okay? So that you engaged in an action, but you were justified in doing it because you had consent to engage in that action. And also that you could say that I did engage in the action, and in fact, I intended to engage in this criminal action, but anyone in my circumstance, they would have done the same thing, and that's why I should not be criminally prosecuted. So let's look at these justification defenses in more detail. So your textbook identifies 4 justification defenses: consent, self-defense, necessity, and the law enforcement, okay? And we're going to take a look at consent and self-defense. Make sure you take a look at necessity and law enforcement as a justification defense, particularly with law enforcement, since that's a really hot topic these days. This idea that law enforcement is immune from criminal prosecution because they're acting on the color of blue, right? That they're acting in their capacity of law enforcement. But we're going to focus on the first 2. So let's go ahead and look at the first justification defense, which is consent. So with the consent defense, basically the criminally accused is arguing through their defense attorney that they did not commit a crime because I had permission to engage in the act, right? And so since I had permission to engage in an act, I didn't commit a crime. Sure, there was an actus, there was an act, but it wasn't a criminal act. It wasn't reus. It wasn't the guilty act because I had consent to do that. Now, consent in and of itself does not automatically excuse a defendant from criminal charges, but it can be used to raise doubt, and that there will be times when defense attorneys will turn to the concept of consent to raise doubt about whether or not a person engaged in a crime. So, for example, we'll go with the second one first, that, somebody who's being charged with some form of larceny or theft, they could say, well, wait a second, I'm being charged with stealing my neighbor's lawnmower, right? But my neighbor said I could come over whenever I wanted to and go in their garage and take their lawnmower. That's not theft. I had consent. They had consented to me to borrow it. So they'd have to, demonstrate that in a court of law. In probably a more serious sense, that when it comes to sexual assault, consent is often scrutinized by those defense attorneys who are defending people from sexual assault charges. Sexual assault all revolves around consent for the most part, right? That if you don't consent to be touched in a sexual manner, right, kissed, fondled, intercourse, if you're not consenting to it, it's sexual assault. And so a lot of times a defense can be, my client had consent to engage in the sexual contact, and so there was no crime that took place here. Now, keep in mind that getting consent in some instances isn't a defense. And so, for example, that minors cannot give consent, right? So going back to the sexual assault, that you could say, And in fact, that's a strict liability anyway, so it's not probably the best example. But with sexual assault of a minor, right, minors can't give consent, right? And so if you're like a 40-year-old and they're like, well, I had sex with a 12-year-old, but they said it was okay, it's like, no, that you have to be an adult to consent. You also have to be non-intoxicated to consent. And so that in a sexual assault case, you can say, well, yeah, they said yes, that you can have sex with me, but the person who you had sex with was intoxicated beyond knowing what was going on, right? An intoxicated person cannot give consent. And also when we're looking at power dynamics, like patients giving consent to their doctors, or clients giving consent to their bosses, right? You say, oh, well, yeah, I had sexual contact with my patient, but they consented to it. That power dynamic makes it difficult to say that it was truly like a voluntary consent, okay? And in some states that actions can be criminalized even if consent is given. And a good example of that is physician-assisted suicide. In many states in the nation, getting assistance from a physician to commit suicide is illegal. And even if the physician says that I had consent for my patient to do that, it doesn't matter that you got consent. The assisting in that suicide, even with consent, is considered a crime. Another justification defense is self-defense. In self-defense, that a person can claim that they are not guilty because they were acting in self-defense, okay? In other words, that yes, I shot somebody, and yes, I intentionally shot somebody, but I did that because my life was being threatened, and anybody in my situation would be justified in acting accordingly, okay? And so they claim that they're not guilty because they acted in self-defense. Now, the defendant must prove that when they acted, they harmed somebody using the justification of self-defense. They have to prove that they acted because there was a reasonable belief that if they didn't act, that their life was in imminent danger or death. And so it's basically like, I took this action because I was facing significant harm. You can't shoot somebody because they were walking too close to you, right? Unless you can demonstrate that walking really close to you is presenting you with some sort of imminent harm or death. Short of that, it cannot be considered self-defense. Also, there has to be like an effort to retreat, right? You're like, okay, I know my life is in danger, but I'm going to get the heck out of here, right? But if there's no way that you can escape, right, and then you can be justified in the use of force to defend yourself, okay? The response must also be proportional, okay? In other words, you can only use the force necessary to prevent personal harm. So if somebody is running after you and shaking their fists at you, right, and you take out a gun and shoot them down, chances are that's probably not proportional. You'd really have to demonstrate that that your life was going to be taken from you if you didn't take their life, right? That you could respond with punching that person, right? Because that would be proportionate. So this is all stuff that would be worked out in the in a courtroom in terms of a criminal defense. You'll read about in your textbook the Castle Doctrine, the stand your ground laws, and this basically means that if you're on your own property, that you can use self-defense without retreating, right? And so it opens up this exception to these other aspects of defending yourself, right? That you have to feel like you're in danger, that you're going to die, that there's no means of escape. The Castle Doctrine allows people to defend themselves in a more like robust capacity. All right, so this is the last topic before our midterm exam, okay? And so after topic 6, we have our midterm exam. And one of the things that we're going to be doing on the midterm exam is that you're going to have an opportunity to apply, either act as a prosecutor or act as a defense attorney, and apply what you've learned last week and this week to a case study, to a hypothetical, okay? to kind of get you geared up for that, there's an extra credit assignment this week, okay? And so when you look in topic 6, you'll see that you can earn up to 10 extra credit points for applying the concepts that we've learned in lecture to a particular case study. And so you'll read the case hypothetical, and then you'll choose one. You'll say that you want to act as the prosecutor, and that you'll think through the elements of the crime, and you're going to prove that Mr. Smith is guilty of second-degree murder beyond a reasonable doubt. Or that you can act as a defense attorney, and using either excuse or justification defense, you get to make a case for why your client is not guilty. You can also raise doubt about actus reus and harm as well. Okay, so this is embedded in topic 6 module for more detail. And if you have questions as you're reading the hypothetical, just reach out to me. I'll give you feedback before the midterm, so that you can use this in case you want to do the case study on the midterm exam. That's it from me. Only one lecture this week. So thanks for listening. I appreciate your time and attention, and I'll talk to you again soon.